The Lagos State Judicial Panel of Inquiry, as constituted by Governor Babajide Sanwo-Olu, has had its inaugural sitting. Members of the public are being invited to submit petitions regarding possible abuses and fatalities that may have resulted from the activities of the now disbanded Special Anti-Robbery Squad. On the flip side, though, a few eyebrows have been raised by the Judicial Panel's conditions for sitting, its overall brief on how to go about the task, and source of information. For instance, would it suffice for the panel to conduct its sittings behind closed doors? For a greater insight on this, we're now being joined by Inibehe Effiong, a lawyer and lead counsel Inibehe Effiong Chambers, a public interest law firm with specialization in constitutional and human rights law. Welcome to the program. Good morning.
Good morning, and thank you for having me.
Inibehe, good morning.
Good morning, Dr. Batsi.
Yes, thank you too for coming. What the Judicial Panel of Inquiry in Lagos looking into the Sars protest, police brutality, and the incident on October 20 at the Lekki Toge Plaza started sitting yesterday. But I'm aware that you sent a letter to the governor of Lagos State under the Freedom of Information Act, asking for a certified true copy of the instrument setting up that Judicial Panel of Inquiry, certified true copy of the instrument imposing curfew on Lagos State on October 20, and then you also want records of the CCTV cameras at the Lekki toll gate. Why are you requesting for this? Is it because you do not trust the Lagos State government? What is your intention? And have you received any response since you sent in that Freedom of Information request?
Thank you. I'll start with the second question. I haven't received any correspondence or communication from the governor of Lagos State yet. By the Freedom of Information Act 2011, the governor has 7 days within which to grant the application, or if the governor comes to a decision that the information sought, the document sought, is within the limited exemptions, what is called exemptions under the FOI, which are documents or information that have been exempted, that applicants are not allowed to have access to. He also has an obligation to write in response to say so. So I have neither received the documents, nor the records, nor an indication that the application has been refused. I will give the governor the benefit of doubt for the 7 days required by law to elapse. Now, why am I seeking these documents and records? It is not personal, so that when we are discussing the issue of trust, it is beyond dispute. It is uncontestable that there is gross deficit between the Nigerian government, the Lagos State government in particular, and citizens on questions of leadership and governance. This trust deficit has been clearly demonstrated by the events of the last 3 weeks. Now, the governor made a public announcement that he had impaneled the tribunal, the panel of inquiry on Sars abuses, and he did say that the terms of reference of this panel or tribunal would be to investigate abuses by Sars. Now, before the panel started sitting, of course, the tragic incident of 20th of October took place, where protesters were attacked by what has now been publicly admitted to be Nigerian soldiers. We have also confirmed some lives were lost. The governor of Lagos State, at least for now, has considered that 2 lives were lost. So the governor now said that he's expanding the terms of reference of the Committee on Sars Abuses to enable them to also investigate what he described in his statement as the Lekki Tollgate incident. Under Section 1 of the Tribunals of Inquiry Law of Lagos State, a commission or panel or tribunal of inquiry can only be constituted, can only be brought into existence through an instrument. The law is very clear that the governor can only do that by issuing an instrument, not by a press statement, not by an announcement on radio or TV or newspaper advertorial. It has to be by an instrument signed by the governor, which I expect to be properly gazetted for that panel to come into existence in the eyes of the law. I am making this point because if the instrument giving birth to this panel of inquiry is not given to me or is not published for the public to see, there would be a reasonable basis to question the legality, the propriety of this panel of inquiry. Having not seen the instrument, I cannot reasonably assume that same exists. I want to believe that the governor knows what is supposed to be done. The governor has an attorney general to advise him. So it is not for me to say that the governor is not aware. Of course, the governor is aware. So the point is this: where is the instrument, particularly when the governor is now saying that the terms of reference of the original panel has now been expanded to include the Lekki Tollgate incident? If there is an instrument that has given birth to this panel and has given that panel this jurisdiction, not only Nigeria, the media also has an obligation to demand and request that this instrument be published so that the panel will not be dissipating energy and public funds, and at the end of the day, the question will arise whether there was actually a commission or a tribunal of inquiry in the eyes of the law. So having not seen the instrument, for me to now appear before this tribunal, this panel, to make representations on behalf of victims or clients or personally regarding the incident that has happened, how will I know that this are actually the terms of reference of this panel of inquiry? I have not seen the terms of reference beyond the omnibus generic statement credited to the governor of Lagos State. To that extent, I am saying that the governor should avail me respectfully of the instrument setting up the panel. Secondly, I am also asking for the certified true copy of the instrument or executive order or directive that proclaimed and imposed curfew in Lagos State on the 20th of October 2020. Recall that the governor had earlier announced that the curfew was going to come into effect by 4 p.m. But before that time, he realized that that time was not practicable. People needed sufficient time to return to their offices. My law firm, for example, we close by 6 p.m. daily, minimum. That's the earliest time that we close. And that applies to many organizations in Lagos State. So the governor, having realized that 4 p.m. was not practicable, extended the time to 9 p.m. Now, the soldiers invaded Lekki Tollgate at about 6:50 p.m. from multiple records. Now, supposing without considering for a second that defying a curfew or violation of a curfew necessitates, justifies, or gives a legal basis for military intervention, the argument is clear that as at the time this attack took place, there was no curfew in Lagos State. So the media must also be mindful of the language that is used to describe what happened. The soldiers did not go there to enforce a curfew, because on the statement made by the governor of Lagos State, the curfew took effect by 9 p.m. So in the eyes of the law, it cannot be said that there was a violation of what never existed, which is why I am calling and demanding that the governor of Lagos State should avail me of the certified true copy of the instrument or the executive order by which this curfew was imposed. This is important for evidential purpose. This is important for transparency. This is also important for me to be able to build a case before the tribunal. And lastly, I am also saying, sir, that having publicly admitted, contrary to earlier insinuations on social media, that the closed-circuit television footage or records are still intact and were not removed, as earlier speculated. Why not publish this? I do not understand why the governor had to say on CNN that the panel will be availed of it. I expect that to be the case, but do not forget that the panel on its own cannot just ask for that document. An application has been made. Somebody has to apply for it. If you look at Section 5 and Section 6 of the Tribunals of Inquiry Law of Lagos State, the power to issue summons, to subpoena for production of documents, issue a subpoena for production of documents or witnesses, has to come by way of an application. So if I am going before the tribunal to say that I am making a case on behalf of the human rights community, I am making a case on behalf of victims who were attacked on that day, some of which have contacted me, shouldn't I be availed? Shouldn't I have proud knowledge of what the CCTV contains? Should I have to wait for the government to determine when to submit it to the tribunal? In law, this is what we call discovery. Before commencement of trial, a litigant has the right to say that the other party should avail him documents, evidence in his possession to help him and aid him in presenting his case. So I do not think that it will prejudice the work of the tribunal for the CCTV cameras or records to be disclosed. As a matter of fact, the public should see it before the panel begins to see it.
Inibehe, sorry to interrupt you, but at this point, let's take a few minutes to have a look at our rights correspondent Sheyiton Atiganu's report on the judicial panel. After that, we'll come back to you.
The Judicial Panel of Inquiry and Restitution for the victims of SARS-related abuses and the Lekki Tollgate incident kicked off with the swearing-in of newly appointed youth reps Rinoola Oduala and Temitope Majekodumi, as well as human rights activist Segun Awosanya.
Amongst all the people of Lagos State, in particular, and Nigeria in general, in all I do.
Please send assurance to the people of Lagos State that we will do our best to discharge justice as it regards SARS abuses and events of the 20th of October 2020. Earnestly and with all it takes to get to the root of the matters.
As the proceedings went into full swing, the first petitioner was called forward to present his case.
I spent about 47 days with Sars at Ikeja. When they did all sorts of things to me, they tortured me. I even know two of their names. One is Inspector Sunday, they call him Baba Ijapa. The other one is ACP Haruna. They call him Babagana. So, I don't know, the torture was just too much. They suspended me, they tore my clothes, used my singlet, hung on my neck, put up a bucket of cement, and bended me like this. A lot of things anyway. My family even did not even know where I was. Until when my mom and my wife eventually came. They started beating my wife and my mom in my presence.
Your counsel.
Members of the panel went ahead to ask the petitioner questions as they deemed fit.
This judgment was delivered on the 26th day of February 2016.
Yes, sir.
About 4 years ago.
Yes, sir.
What efforts have you made to enforce the judgment?
You mentioned two names, Inspector Sunday, a.k.a. Baba Ijapa, yes, and ACP Haruna.
Yes.
ASP, thank you. Did they ever appear in any of the proceedings?
No.
Are you aware if any disciplinary action has been taken against them?
Not at all. I'm not aware.
You are not aware?
Is a very important task that has been assigned to the panel, and we therefore need all hands on deck to unravel a lot of things that has happened in our society, particularly the incident of the 20th of October 2020. And we as a state are determined to get to the bottom of that matter.
The second petitioner, Mr. Ndukwe Ekekwe, who attributed his being in a wheelchair to SARS operatives, was not able to deliver his testimony.
The petition shows the name of one Hamzat Haruna as a SARS operative who the evidence is against. We have sent a summons to the Commissioner of Police, Lagos State, for him to attend proceedings before this panel. He is not here with us today. In view of that situation, since he is known and we have his phone number, the tribunal is of the view that the matter will be adjourned.
The president of the Nigerian Bar Association, Olumide Apata, reiterated the commitment of the organization to provide legal counsel to petitioners who couldn't procure one themselves.
I'm glad to see that the council is representing the parties today, but as we have indicated before now, in the event that there is any victim who is unable to procure the services of the lawyer, the NB will organize for that person to be represented, this panel and the others around the country.
As assured, even the cooperation of members of the association to assist where petitioners do not have counsel. They should not be discouraged. They should come up. Already, the leadership has given instruction that we should take up pro bono to all the branches. And I know lawyers will be willing. They assure us they will be streaming it live. I want us to do that and to televise this thing live because it's part of the healing process. It will attain the status of the Puta panel. They will televise live. We were made to wait for 2 hours. Scheduled to start by 10, but this particular sitting started by 12:13 or 12:15. That was not nice at all. The other thing is that you can't blame the panel. There were 4 petitions to be heard due to no fault of the panel. Only one could be heard, and it was heard very well.
First public hearing of the Judicial Panel of Inquiry ended at approximately 1:32 p.m. This could be attributed partly to the fact that only one petitioner was able to present his case. The next hearing will take place this Friday, October 30th, here at the Court of Arbitration. I'm Shaiton Atigari reporting for Arise News.
Shaiton Atigari there, Arise News correspondent. Filing a report on the Judicial Panel of Inquiry set up by Lagos State Government. You're still watching The Morning Show, and our guest is still here with us, Inibehe Effiong, a lawyer and lead counsel, Inibehe Effiong Chambers. Inibehe, sorry to interrupt you. If you could just wrap up on that statement you were making earlier about the FOI letter you sent to the Lagos State Governor.
Yeah, so I made the point that for the sake of transparency, for the sake of the credibility of the panel, I do not have any fear about the integrity of the members of this panel. I know some of these members, for example, Mr. Bongodeguruwa is saying, I know he is going to do what is right. I know some other members of that panel. But what I am saying is that we cannot divorce the functionality, the efficacy of the tribunal or the panel from the government that brought it into existence. So it is also in the interest of the governor and the people of Lagos State for the records to be made available. Like I said earlier, at this moment, I can only assume, I can only rest my belief on conjecture that there is an instrument issued by the governor, signed by the governor, that has brought this panel into existence. But to speak factually, there is no document, there is no evidence that this panel had been set up in line with the law. I had expected the governor of Lagos State or the government of Lagos State to publish the instrument. Let us see the instrument. If you have actually set up a judicial panel of inquiry, the law says it can only be done by an instrument. What they did was just a press statement or a public statement by the governor. So in the eyes of the law, except that instrument is being concealed from the public, there is no evidence that this panel has been brought into existence in conformity with the Tribunal of Inquiry law of Lagos State. It doesn't cost anything. This can be done within an hour. Let the governor bring out the instrument as, applied for to assuage these fears that I have expressed, so that this panel at the end of the day will not be plagued by illegality or question as to the appropriateness of this panel, continuing to hold proceedings. Now, we have seen what has been going on. Just yesterday, there were reports on social media that the members were being asked to sign oath of secrecy. This is what I'm talking about. There is what is called perception, and in conflict management, sometimes perception looks like reality. When we have a situation that the government had earlier denied that there was any form of attack, the military is still playing this funny, ridiculous game by not owning up to the role they played. It was just last night that they belatedly admitted passively. They didn't even admit in clear terms their role, to say that they were invited by the governor of Lagos State or by the government of Lagos State. So what is the point I am making? The antecedents of this crisis, the NSAS movement, supports a strong case for transparency. If the governor is committed to a transparent investigation, let the evidence be put out and let people be held accountable. I am hoping that this panel of inquiry will issue a subpoena compelling the Chief of Army Staff, General Buratai, to appear to testify. He should be compelled to testify. Because under the Tribunal of Inquiry Law of Lagos State, Section 5 and 6, the panel has the power to summon anybody throughout Nigeria, not only in Lagos State, to facilitate the work of the tribunal. So we need the army on the witness stand. We need them to come and explain their role. We need them to be cross-examined. People must be held accountable. But here is the fear that I have. At the end of the day, in the final analysis, the truth of the matter is that Governor Sanwo-Olu does not have the constitutional or legal power to enforce the decision of this panel. That is the truth. He cannot enforce it legally. He can only recommend or submit the report to the president for action. And Dr. Bassi, do not recall that the last time I was on this program, I did mention that we seem to have a president who is perpetually on vacation, and you tried to correct me that no, that the president is not on vacation.
Mr. Effiong, it's not a monologue, it's an interview. We're having a conversation. I want to stop you where you said about the governor not being able to enforce the judicial panel. We've seen this before. That's what happened in Kaduna State with what was called the Shiite massacre, when Governor El-Rufai had established a judicial panel, indicted several military officials, names were named, and there was no enforcement. How do we avoid that outcome this time? And my second question for you relates to your comments about having a subpoena issued to the military and having them cross-examined and what have you. Are you conceding that the proper place to interrogate the events of the 20th of October is this panel that was set up to investigate the excessive of the now disbanded Sars, or should there be a separate panel entirely so that we don't get confused with these important issues?
Well, in the final analysis, it boils down to political will on the part of the president to do what is right. When members of the Islamic movement of Nigeria were gunned down, it is documented, it is proven by empirical evidence that not less than 330 members of the IMN were slaughtered, were massacred, and buried in shadow graves. The same Nigerian military, under the same Chief of Army Staff, denied that this attack took place. Till date, even when the Judicial Panel of Inquiry, empaneled by the governor of Kaduna State, reached a conclusion and indicted the military and recommended prosecution, till date, no soldier has been court-martialed to my knowledge. Nobody has been tried for murder. Nobody has been relieved of his duty. Between 2015 and 2016, it has been documented by Amnesty International, which has not been discredited, that not less than 150 members of the IPOB, Independent People of Biafra, were killed. One of those attacks took place on the 30th of May, 2015 or 2016, during the Biafra Remembrance Day. when members of IPOB in dozens were slaughtered and killed. Nobody has been held accountable. Nobody has been prosecuted. So we have antecedents of impunity. We have a culture of disregard for accountability. We have a president who has deliberately refused to hold officials of the armed forces who have been implicated in war crimes, in crimes against humanity. Because what took place in Kaduna, what took place in Onitsha, in Anambra, was nothing but crimes against humanity. Even in a state of war, supposing Nigeria is in an armed conflict with a foreign nation, it is not allowed. The Geneva Convention prohibits the attack of wounded and surrendered armed combatants. How can you, as far as I am concerned, the Nigerian nation, if at all it ever existed, died on the 20th of October 2020. People were singing the national anthem, raising the national flag. These are supposed to be sacred national symbols. These are supposed to be things that should unify us as a country. And you have an armed forces, people who swore to an oath to defend the integrity of this country, to protect these same symbols, opening fire on people who were singing the national anthem. So I do not think for a second that we have to wait for this panel to conclude its assignment before somebody is held accountable.
Real quickly, let me ask you this. If you can hear me, Inibe, real quickly, let me ask you this. This that you're looking for to get all of this through, this means to be able to get the footage and all the documents. If you don't get it, what do you do? Real quickly.
We'll go to court. I have not ruled out the possibility of going to court. It is in the interest of the people of Lagos State. It is in the interest of the government of Lagos State, and also in the interest of the panel of inquiry. People have asked me, well, why didn't you go to the panel to request for this document? The answer is simple. The instrument that gives birth to this panel of inquiry is not vetted, was not given birth to by the panel.
Well, thank you, Inibe.
It is the governor of Lagos State. Only the governor can issue the instrument. Only the governor can declare or impose a curfew.
Point well made.
So the governor has an obligation to publish it, to convince us that really there is a judicial panel of inquiry. Until I see that instrument, I will continue to raise doubt on the legality of this panel. And the media has an obligation to demand that this instrument be published. You cannot declare or impanel a commission of inquiry by press statement. The law says it has to be by instrument.
Thank you very much. Thank you for joining us.